So, Your Honor, I have Mr. Javier Martinez Brooks before the court. Case is 21-2576 CF, which is a violation of probation. 21-2811 CF, which is also a violation of probation. We have 24-2986 CF, Your Honor. In the VOP cases, the defendant would withdraw his previous denial and admit to the violation of probation. In both cases, he would be sentenced to 48 months in the Department of Corrections. He had previously served time in the Department of Corrections, so he would get, I believe, 36 months credit towards his charge, or the 48 in regards to that. And then it's my understanding that he has 318 days jail time credit that has been served. Mhm. And as part of the negotiated sentence, these would run concurrent. He would have to pay any court cost fines that would be imposed. He stipulates to the facts in the probable cause affidavit as a prima facie basis for the offense, and the Department of Highway Safety Motor Vehicles may apply additional penalties. He will be sentenced to time served on any misdemeanors. He'd have to provide a DNA sample, forfeit any seized items. And that is the negotiated disposition. I've gone over the plea form with my client. My client signed, the state signed, I have signed, and he has completed his court cost form. And I think in case number 242986, the state would be.
It's on the felon in possession of the firearm charge.
All right, so on the VOP, we get credit for time served in the prison plus 300 and something days. Okay, but on the new charge, you just get the 300 and something days.
Correct.
Okay. Mr. Brooks, do you understand that?
Yes,
The one that's going to really control how long you stay is the new charge, right?
Yes, sir.
Or new charge is 48 months with credit for 318 days. That's really going to determine how long you stay, because the VOP you're getting 48 months with the same plus your DOC time, right? Which is not all written on here. Okay.
Yeah.
Oh, it is?
Yeah, that's what it is.
Okay, all right, I missed that. So it's time served.
Just the misdemeanors. Right.
So we're not trying to tell what the prior DOC is. We're just going to say, let them figure it out.
Madam Clerk is telling me that they do.
Okay, that's right. I don't mind. So you get all the credit you served already, which Mr. Middleton thinks it's close to 3 years,
36 months. Would serve the DOC.
plus 318 days, and you're getting 4 years. So you may not be there very long, but you may be. It's up to the DOC to determine how much of that you get. You understand that?
Yes, sir.
Okay. Are you under the influence of any drugs, medications, or alcohol?
No, sir.
Has anybody forced you, threatened you, or coerced you to enter a plea?
No, sir.
Has anybody promised you anything other than what's on this
No, sir.
paper? No. Is there anything at all about you today that would keep you from understanding what's going on?
No, sir.
Okay. So on your misdemeanors, you're getting time served. On your felony case, you're getting 48 months, less DOC credit, less 318 days.
Yes, sir.
None of the four of us, me, Mr. Middleton, the state, or you are doing the math today, right? You understand the DOC will credit that, but you'll get credit for every day you served. I just don't really know if they give you credit if you got gain time, whether you get credit for the whole sentence or just the days you serve. But that's the DOC to figure that out, okay?
Yes, sir.
Is there any DNA flying around out there we need to know about?
No, Your Honor.
Sir, do you have any questions before I impose that sentence fully?
No, sir.
I think I've already stated the sentence. You will pay fines and fees. Do we have an amount? Let's see. $100 for cost of prosecution for the VOP. No money on the misdemeanors?
No.
Okay.
I'm working on an app.
And
for that,
were
for record.
the ones that are misdemeanors are ones that were there in circuit court, right?
Yes.
So I don't have to come up with any other numbers.
We'll
All right,
stipulate
sir.
the-
Well, that sounds good. Last one, but it's the most confusing one of the morning.
That was by design, Your Honor. We were trying to see if you were on your toes.
No,
Been a lot of horse trading back and forth.
I think we've got it figured out. As long as Mr. Brooks knows what's going on and you're ready to go ahead. Sentence is imposed as laid out. Take care, sir. I don't think you'll be there very long. All right, are we all done? Okay, thank you all. It's good to see everybody.
All right, let's talk about that. This hearing wrapped up with a complicated but well-negotiated plea deal for Mr. Javier Martinez Brooks, who was facing not one but 3 separate cases, 2 violations of probation and 1 fresh felony. And while the legal math got a little tricky, the courtroom stayed focused, lighthearted at times, and above all, clear about what was going on. Mr. Brooks withdrew his previous denial and admitted to violating probation in 2 cases for both VOPs and the new case, which included a felon in possession of a firearm charge. He agreed to a consolidated sentence of 48 months in the Department of Corrections. Now, here's where it gets interesting. He's credited with 318 days of jail time and, according to defense, around 36 months previously served in dock. So while it's officially a 4-year sentence, his actual time left may be significantly less. The judge was careful to explain that dock, not the court, determines exactly how much credit he'll get and how soon he might be out. Throughout, Mr. Brooks remained calm, clear, and respectful. He answered each of the judge's questions, directly confirming he wasn't under the influence, hadn't been pressured, and fully understood what he was agreeing to. There was no confusion on his end, even if the paperwork had the judge double-checking with the clerk just to make sure everyone was on the same page. And speaking of paperwork, this case had a lot of it, between multiple case numbers prior, DOC time, and cross-crediting sentences. It was one of those moments where the courtroom turns into a bit of a spreadsheet. But to their credit, the judge and counsel worked through it carefully, even joking that this was the most confusing one of the morning, by design. Still, despite all the legal layering, everyone kept their sense of humor. The judge even added, "I don't think you'll be there very long," which may not be a legal guarantee, but it's about as encouraging as it gets in a sentencing hearing. At the end of the day, this case shows how courtroom resolution doesn't always look dramatic. Sometimes it's just about making sure the math adds up, the paperwork matches, and the person at the center of it all understands what's next. In this case, Mr. Brooks got exactly that, a fair deal, clarity from the bench, and possibly a shorter time ahead than the sentence suggests. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one,